We begin in Halifax tonight, where outrage over a ruling in a sexual assault case had people protesting in the streets, calling for the judge's removal. Today, the Crown announced it is appealing the case. Criticism has been mounting since last week when Judge Gregory Lenehan acquitted a cab driver accused of sexually assaulting an intoxicated passenger.
Someone is too drunk to say yes, they are too drunk to say no.
Crown Counsel says its decision to appeal is not based on public pressure, but about the law. Much of that pressure has been directed toward the judge himself, but demonstrators also say they want the complainant to know they believe her. For more on the outrage and the reaction, Sarah Galashan joins me. Sarah.
Yeah, well, you can see, Nancy, from the protest, there is a lot of anger, and it's not just to do with the specifics of the charges here. A lot of it is to do with what the judge said during his decision. I want to play you a little more of what we heard from the crowd in Halifax.
This has gone on for too long. There's way too many examples of this, and we're sick of it.
Just outraged that this has happened. Even if the horrible thing that the judge said was true, that she might have given consent previously, as soon as she was no longer conscious, that consent would have gone away.
To be fair, the judge did make the point in court that a person who is unconscious clearly can't consent, but then went on to explain that he reasons that this does not mean, however, that an intoxicated person cannot give consent to sexual activity. Clearly, he said, a drunk can consent. And it's that last sentence in particular that has sparked so much outrage. Tens of thousands of people have signed a petition calling for that judge to face a public inquiry, and others simply want to have him removed from the bench. There are those who are speaking out in defense of Judge Gregory Lenehan, and that is the Criminal Lawyers Association of the province. They are describing him as someone who is fair, respectful, and compassionate, and they're angry about all of the anger on the street. They say that many of those protesters in their minds are uninformed because while this case was widely publicized as a case of a woman who was drunk, got into a taxi, was found by police unconscious, undressed from the chest down, and the taxi driver found with his pants undone, the Lawyers Association argues that those basic facts really simplify things. And Nancy, as you know, having been in court before, oftentimes it is true that arguments and evidence that are presented in court are often more complicated than what we just read in a headline.
And yet, the Crown has decided to appeal and says it has nothing to do with the public outrage on this.
Right, and the Crown is appealing. They had up to 30 days to make that appeal. This decision was just announced last week, and they say it's a short decision. They've gone through it, and they are ready to file that appeal. And they say, yes, it has nothing to do with the petitions and the protests.
We can't say, well, there's public outrage, so therefore we have to go ahead with an appeal. We have to review it, make a determination that there is an error of law, an actual legal error that we can proceed upon. And that's the only way, as the Crown, we're allowed to appeal.
In fact, she says they found 7 errors in law, and 6 of them specifically deal with the handling of the consent issue. So where does this leave the taxi driver, Bassam Al Rawi? I mean, he is going to be, according to the Crown, served with a notice of appeal, but there are several processes that have to take place, likely going to be months before any appeal is heard in court. In the meantime, his lawyer is actually speaking out in his defense. He issued a statement. I want to read you part of it. It reads, nowhere in all of the public discussion about this case is there the suggestion that the judge was right. Mr. Al Rawi might actually be innocent. And in fact, he was found not guilty. So he is free. He's out. His lawyer and the police actually cautioning anyone who might be angry against any form of vigilante justice. Nancy, they make the point, and rightfully so, that this is a process that needs to play out in court.
And we will be following it. Thanks very much, Sarah.
You bet.
Karen McArthur is a criminal defense lawyer. We wanted to get her take on this. So, Karen, first of all, were you surprised by the Crown's decision to appeal?
Not at all. It's absolutely the right thing to do. This is such a critical piece of figuring out whether or not you're guilty or innocent, whether or not there's consent. And the way the judge dealt with it, it necessarily had to be appealed.
What was it specifically about the way the judge dealt with it that you thought was grounds for appeal?
He speculated that you can consent, and there wasn't any evidence before him that she had consented to the sexual activity. The facts is what he has to judge on. He can't speculate. He can draw logical deduction from the facts that are presented to him. But one of them, as I understand from the facts, was not that when she got into the cab, she would have been sober enough to have consented. The evidence was that she left a bar, she couldn't remember what had happened at the bar, and she was drunk when she got into the cab. Sexual assault, you can't consent to sex if you don't have the free will to consent. And you don't have the free will if you're too drunk.
So now, as you say, not a surprise that the Crown's gone ahead with the appeal. Does the appeal stand a good chance of being granted? Will we have another trial, do you think?
I think the Court of Appeal will direct a new trial, and a new judge will then look at the facts and appraise them and specifically direct his or her mind to Section 273.1 of the Criminal Code, which says for sex to take place, there has to be a voluntary agreement between the two adults. And you can't have that agreement if you're too drunk. Pretty simple.
Yeah, it's funny because this is not the first time we've talked about a judge saying this sort of thing. We think of Judge Robin Camp and his comment about a woman, can't she just keep her knees together? Is there, you practice law, is there a more pervasive problem? Is there something that the justice system needs to look into in terms of attitudes?
Well, I think they're continually being re-educated, re-schooled in what is or isn't a sexual assault, what can constitute consent and what cannot. I don't think there's a pervasive problem, but there are problems. The fact that they are found out, they are appealed from, judicial inquiries are held, tells me that we get it right. It might take a few bumps along the road to get it right, but the positive side to the bumps along the road is that the public gets educated about how their justice system works. Recall, after all, that the justice system is paid for by the taxpayers. It is theirs.
And is this maybe a generational thing? Is this, are younger Canadians learning more about the idea of consent and older Canadians sort of learning as we go along through these bumps?
Yes, I think that's probably true. Kids in schools today are educated about what is or is not consent, what they can or cannot sext or text. So there is a bit of a generational divide, but getting back to first principles, our legal system is based upon volition, upon free will, and contract law, which is really what comes to bear here in sexual assaults, you have to have an agreement. Those are basic principles that go beyond this generation or an older generation. It's just that we have to be rational as we decide things, as we decide these disputes.
All right, thank you so much for your insight tonight.
You're very welcome, Nancy.